Joining us now, former FBI General Counsel Andrew Weissmann and Robert James, former District Attorney for DeKalb County, Georgia. Welcome both. So, Andrew, first to you. Meadows was arguing, and arguably had the strongest argument in this group for removal, other than the president, of course. How big a win is this for DA Willis? Judge Jones said that he's going to be considering each case individually on its merits, and he's ordered a hearing tomorrow on Meadows' argument for an appeal. Or the judge has ordered, the appeals court has ordered a hearing tomorrow.
So huge win, and the federal judge, being very careful, has said that he is going to hear each of the other cases individually. In other words, for each of the people coming up, whether it's Jeffrey Clark or the so-called fake electors, he's going to hear theirs based on their own facts, and anything that they want to say with respect to his legal findings, he will hear them what's called de novo, anew. But it obviously is an uphill battle for them. Meadows, I think, probably had the strongest argument, and that was rejected. I think the fake electors probably have the worst argument. You can't really claim that you had federal office because you were pretending to be an elector when you weren't. So we'll see what happens in the hearings this week. But I'm pretty sure that the people who are doing that are thinking their best chance might be on appeal, but not before the district judge, that he's going to likely follow the same ruling he made with respect to Mark Meadows.
And I think I muddled that, by the way, Andrew and Robert, because it is the district judge, Judge Jones, who is going to hold an expedited hearing tomorrow on the request by Meadows for a stay of the order, the order rejecting his move to federal court. So, Robert, had this moved to federal court, Meadows would have had a broader, more conservative jury pool, arguably, no cameras in court. And that is obviously what's fueling the request. Does Donald Trump, as the president, have a better argument?
I think he has a better argument. I mean, he's obviously a federal official. So at a minimum, it's going to be on the same level as Meadows. I agree with the former FBI counsel that the other individuals involved, the further down the chain you get, the weaker it gets. The fake electors don't have much of an argument at all. The judge said he wants to hear each case on its individual merits, on its individual facts, and so it's going to be interesting to see if there's any difference between the two if former President Trump does make an argument. But I understand why a criminal defense lawyer or why a criminal defendant would want out of Fulton County in a scenario like this and into the Northern District of Georgia.
Now, Andrew, separately, the unsealed special grand jury report, not the indicting grand jury, revealed that 21 others had recommended 21 people for indictment, but they were not indicted by Fani Willis. And this includes 3 current and former senators, including Lindsey Graham, notably from South Carolina. And Chuck Rosenberg, our colleague and friend, was arguing this morning on Morning Joe that he thinks it's really unfair to release these special grand jury reports because these people have no recourse to defend themselves. They don't go to trial. They can't try to clear their names. And there's an implication when you say that a special grand jury recommended this. And I know it was in response to media lawsuits, including NBC. So I'm wondering what you think about the fairness of this, Andrew.
It is lawful under state law to do this. So nobody has done something improper. But I agree with Chuck. Mary McCord and I were just talking about this on our podcast, which is in the federal system, it is basically colloquially known as you put up or you shut up, meaning that a grand jury either indicts, in which case the person, it's publicly known and there's a trial and all of the due process rights, or you have to stay silent. One of the reasons many people who were in the department were so angry with James Comey when he spoke about Hillary Clinton was that it was so against the idea of due process, that you don't give your personal views about somebody who was not charged. And so I agree with Chuck that this is really unfair to them. I would note, though, that the judge who unsealed this, not only was he complying with law, but his cover memo does say that he gave the opportunity for everyone to object to this becoming public. So that's what he said. I don't know whether that is accurate or inaccurate, but he apparently did give the people who were the subject of these recommendations an opportunity to object. And he said that there were no objections. So to the extent that that is true, that would undercut the claim of this being unfair, because people did have an opportunity to object and apparently did not.